Thank you, Mr. Speaker, and I rise today to offer my objection to Bill S-7. But before I move forward, Mr. Speaker, I want to, of course, express my condolences, of course, to the families and victims in Boston. I know from every MP in this House, no matter what color of our tie or where we sit in the House, we all condemn this heinous attack. But jumping to the bill at hand now, Mr. Speaker, this bill would amend the Criminal Code, the Canada Evidence Act, and the Security of Information Act with the expressed purpose of combating terrorism. However, Mr. Speaker, it is my belief, and the belief of numerous groups who appeared before the Standing Committee on Public Safety, that this bill offers nothing in the way of protection from terrorism, and that the limits it places on civil liabilities are simply unacceptable. The main component of this bill is an amendment to the Criminal Code which authorizes investigative hearings and the imposition of recognizances with conditions, as well as authorizing preventative detention in cases where a person declines to accept or fails to adhere to the conditions of their recognizance with conditions. In non-legal jargon, what does this mean for Canadians, Mr. Speaker? Well, essentially, the first part means that any peace office, a police officer or an office in the Canadian Forces, for example, can ask a provincial judge to order anyone who might, and I emphasize might, Mr. Speaker, have information concerning a terrorist act to appear before a judge. If a provincial judge makes that order, a person must submit themselves for an interrogation where they must respond to all questions and are required to bring with them any possessions that are connected with the judge's orders. These hearings can be about past or ongoing crimes or suspected future crimes. Mr. Speaker, the bill states that the purpose of an investigative hearing is not to prosecute individuals, but in order to gain information. Because of this, responses given during an investigative hearing cannot be used against the individual in the context of future criminal proceedings, except in the case of prosecution for perjury or giving contradictory evidence at the hearing. However, other non-criminal legal proceedings, such as extradition or deportation proceedings, are not expressly covered by the bill, meaning that individuals could still find themselves negatively affected by their appearance. The second part, Mr. Speaker, regarding recognizance with conditions, essentially means that a peace office can attest or can arrest an individual without a warrant if they believe that such an arrest is necessary to avoid a terrorist attack. The individual who has been detained must then be brought before a judge within 24 hours of detention or as soon as possible in order to prove the necessity of detention. The peace agent must then ask a provincial judge to order that this individual appear before a judge to determine whether recognizance, which is a legal obligation for an individual to respect certain specific conditions, is necessary. While the limits of what conditions a judge can set or not detail in the bill, it does explicitly state that one condition that a judge may impose is to prohibit that person from owning weapons, including firearms, crossbows, or ammunition. If an individual refuses to abide by the terms of the recognizance, they can be imprisoned for up to 12 months. This imprisonment, not being the result of a criminal conviction, is thus described as preventative detention. These conditions, Mr. Speaker, can therefore allow any Canadian to be imprisoned for up to 12 months without ever being charged or convicted of any crime, Mr. Speaker. But this will never affect me. I am a law-abiding citizen. Only people who are carrying out terrorist activities will be covered by this bill, I hear many say. Well, Mr. Speaker, they would be wrong. For one thing, if there is sufficient evidence that these people were planning on carrying out terrorist activities, then they would be charged with a criminal offense. Clause 83.182 makes planning a terrorist activity a crime whether or not the terrorist attack is actually carried out. Knowingly aiding a terrorist group to carry out an attack is also covered by the Criminal Code in Clause 83.18(1). There cannot therefore be proof beyond reasonable doubt that an individual is aiding or planning terrorist activities, or they would be charged under these clauses, Mr. Speaker. Even so, our contrarian adds, Mr. Speaker, there must be suspicion that they are involved in terrorism. It would never affect people like me. Well, Mr. Speaker, that argument is short-sighted on two levels. Firstly, and more generally, let us remember the poem attributed to German pastor Martin Niemöller. There are many variations of the poem, but the final line is pretty much universal. Then they came for me, and there was no one left to speak for me. If we so easily give up the civil liberties of others, we cannot be surprised if later our own civil liberties begin to be eaten into, Mr. Speaker. Secondly, and more specifically, the wording of this bill means that the erosion of our own civil liberties is near. During the clause-by-clause review, Mr. Speaker, of the bill at the Public Safety Committee, it was discovered that the government had intentionally worded the clause relating to the recognizance with conditions so that people who are not themselves suspected of terrorist activity can be subject to such conditions. The discovery, Mr. Speaker, was made as the NDP proposed to amend the recognizance with conditions provision to make sure it was clear that only those determined to be potential participants in a terrorist activity could be subject to the clause. Mr. Speaker, the NDP are opposed to the imposition of recognizance with conditions completely, but we felt that this amendment would at least prevent the imposition of recognizance with conditions on individuals not suspected of involvement in terrorism, a serious abuse that we felt the Conservatives surely did not intend, Mr. Speaker. However, Mr. Speaker, it appears that we were wrong to think that this was an oversight and not a targeted attack on Canadians' civil liberties. A parliamentary secretary told the committee that the Conservatives would not support the amendment because the wording was specifically intended to have a broad sweep to ensure that it included people not themselves suspected of engaging in future terrorist activity. Mr. Speaker, there in the Public Safety Committee, the Conservatives admitted it. They were bringing forward legislation with the intention of being able to enforce conditions or imprison for up to 12 months people who have no involvement in terrorist activities under the pretense of a bill to combat terrorism. Even worse, Mr. Speaker, they are now using this tragic events in Boston last week to push through this attack on civil liberties. Unfortunately, Mr. Speaker, terrorism is a real threat in many countries, including our own. But this bill will do nothing to ensure that Canada is protected from terrorism. When the provisions for investigative hearings, recognizance with conditions and preventative detention were previously in place from 2001 and 2007, they were not utilized once, Mr. Speaker. And in that time, the RCMP successfully foiled a planned attack in Ontario, leading to the arrest of the so-called Toronto 18. Again, the RCMP, Mr. Speaker, was successfully able to stop a planned terrorist attack earlier this week without these Big Brother-esque provisions. Bringing in legalization that allows the government to detain people without evidence that they are carrying out attacks is useless at best, Mr. Speaker, and in all likelihood, much worse than that. Mr. Speaker, I am not alone in condemning this bill. I will leave the final word, Mr. Speaker, to Mr. Paul Colarecco of the Canadian Bar Association. There is in no question that the prevention of terrorist action is vital to preserving our society. This requires effective legislation, but also legislation that respects the traditions of our democracy. Unfortunately, this bill fails to achieve either goal, end quote. So, Mr. Speaker, I urge this House to reject this legislation. Thank you, Mr. Speaker.